डॉक्टर बाबासाहेब आंबेडकर ओपन युनिव्हर्सिटी.
Good evening, friends. I, Dr. Dhaval Pandya, welcome you all from the Chaitanya Studio of Dr. Babasaheb Ambedkar Open University. Today, we are going to learn about MBA01's subject, Business Law. The subject code is MBA01C106, Unit number 2, Indian Contract Act 1872-II. The syllabus is like first, discharge of contract, then comes remedies to breach of contracts, then performance of contracts, then void agreements. What is void agreements? We'll learn contingent contracts, quasi contracts, spatial contracts, contracts, indemnity and guarantee, contract, bailment and pledge, contracts of agency, first we'll start with discharge of contract. Spatial contract, these are the syllabus. We'll start with discharge of contract. In today's lecture, we'll cover these two things, discharge of contract and remedies to breach of contracts. This unit is too long, so we'll cover these two topics only in today's lecture. So discharge of contract and remedies to breach of contracts. We'll start with discharge of contract. What is discharge of contract? Discharge of contract means termination of the contractual relationship between the parties. The contract is said to be discharged when it calls to operate, like when the rights and obligation created by it comes to an end. The various modes of discharge of contract can be diagrammatically explained as we'll see the chart first. We'll learn with the chart. Okay. This chart will help. First, mode of discharge of contract, then by performance, actual and attempted, by impossibility of performance, by lapse of time, and by breach of a contract, actual and anticipatory. Then comes by mutual agreement. What it means? By implied consent. Section 62, 62 and 63, and by operation of law, death, merger, insolvency, unauthorized alteration, and by mutual agreement, what will be the subtopics? Novation, recession, alteration, remission, waiver and merger. So we'll cover all these things in this topic. So first we'll start with discharge by performance. Discharge by performance takes place when the parties of the contract fulfill their obligation arising under the contract within the prescribed time. This is the most useful mode of discharge of a contract. Performance may be actually performance or attempted performance, like tender. by actual performance. What is by actual performance? And by attempted performance. Attender. Discharge by agreement or consent. It is as it is the agreement of the parties which binds them, so by their further agreement or consent the contract may be terminated. The rule of the law in the regard is like a thing may be destroyed in the same manner in which it is constituted. The various cases of discharge of a contract may be mutual agreement are: first, novation, recession; third, alteration; fourth, remission and waiver. And last one is a merger. Now we'll talk about discharge by impossibility of performance. Discharge by impossibility of performance. It is an agreement contains an undertaking to perform impossibility. It is void ab initio. This rule is based on the following maxims. First, the law does not recognize what is impossible, and the second is what is impossible does not create an obligation. According to Section 56 of the Indian Contract Act, impossibility of performance may fall into either of the following categories, like which one? First, impossibility existing at the time of the agreement. May the parties or unknown to the parties known either. The former is known as absolute impossibility. Second, supervising of impossibility. A contract is discharged by supervising impossibility in the following cases, like can be an excuse of discharge of contract. First, destruction of the subject matter of the contract. Second, non-existence or non-accuracy of a particular state of thing. Third, death or incapability for personal services. Fourth, change of law. And fifth, outbreak of war. Under the following circumstances, a contract is not discharged on the ground of supervising impossibility. First, commercial impossibility. Second, difficulty of performance. Third, impossibility due to failure of the third person. D, strike, lockdown, and civil dispersances. E, failure of one of the object. Now, discharge by operation of law. Discharge by operation of law. A contract may be discharged independently of the wishes of the parties, like by operation of the law under the following circumstances, which are by death, by merger, by insolvency, and by unauthorized alteration of terms of contract. Now, discharge by lapse of time. The Limitation Act 1963 lays down that the contract should be performed within a specific period called period of limitation. Fifth, discharge by breach of contract. discharged by breach of contract. Breach of contract means a breaking of the obligation which a contract imposes. It occurs when a party of the contract, without lawful excuse, does not fulfill his contractual obligation or by his own act makes it impossible that he should perform his obligation under it. It converts a right of action for damage to the injured party. Breach of contract may be actual or anticipatory. Actual breach. Actual breach of contract, it means it may take place at the time when the performance is due during the performance of the contract. Second, anticipatory of contract. It occurs when a party of an executory contract declares his intention of not performing the contract before the performance is due. He may do so by express repudiation or by implied repudiation. Remedies for breach of contract. When the contract is broken, the aggrieved or injured party, like the party who is not in breach, has one or more of the following remedies, like rescission of the contract. First, suit for damages, suit upon quantum merit, suit for specific performance of the contract, suit for injection. Now, rescission of the contract. Rescission of the contract. When a contract is broken by one party of the other party, may sue to treat the contract as rescinded and refuse further performance. In such a case, he is absolved of all his obligation under the contract. The contract may grant rescission on the following ground, which are the grounds: where the contract is voidable by the plaintiff, or where the contract is unlawful for cause not apparent on his face and the defendant is more to blame than the plaintiff. The contract may, however, refuse. In this particular case, the court may, however, refuse rescission of the following ground. Which are these ground? Where the plaintiff has expressly or impliedly retained the contract. Second, where owning the change of circumstances, the parties cannot be restopped or their original position. Third, where third party have during the subsistence of contract acquiring right in the good faith and for value. D, where only a party of the contract is sought to be rescinded and such party is not severable from the rest of the contract. Second, damage. Damage are a monetary compensation allowed to the injured party by the court for the loss or injury suffered by him by the breach of the contract. The object of the awarding damage for the breach of a contract is to put the injured party in the same position so far as money can be it as if he had not been injured. This is also called the doctrine of restitution. Types of damages. Damage may take in any of the following forms like ordinary damage, special damage, then vindictive or exemplary damage, fourth, nominal damage, five, damages for loss of reputation, six, damages for inconveniency and discomfort, liquidate damage. Ordinary damage, what it means, ordinary damage. When a contract has been broken, the injured party can recover from the other party. Such damages are natural and directly arise in the usual course of things from the breach. This means that the damages must be the approximate consequences of the breach of contract. These damages are known as ordinary damages. Normally, ordinary damages in the contract for the sale of goods are the difference between the contract price and the market price for such goods on the date of the breach. Then come second, spatial damage. Damages other than those arising from the breach of the contract may be recovered if such damages may reasonable be supposed to have been in the uh, contemplation of both the parties as the probable result of the breach of the contract. Such damages are known as spatial damage. Spatial damage cannot be claimed as a matter of right. These can be claimed only if the spatial circumstances which would result in the spatial loss in the case of breach of the contract are brought to the notice of the other party. Third, vindictive damage. Damages for the breach of the contract are given by way of the compensation for loss suffered and not by way of punishment for wrong inflicted. Hence, vindictive or exemplary damage have not place in law of contract because they are punitive. Punitive or uh, involving punishment by nature. But in the following two ground, the court may award exemplary damages. First, breach of the uh, promise to marry and dishonor of the check by the banker wrongfully when the customer possesses sufficient fund to the credit of his account. Then comes fourth, nominal damage, where the injured party has not in the fact suffered any loss by reason of breach of the contract. The damage recoverable by him are nominal, like very small. For example, a rupee. This damage merely acknowledge the plaintiff has provided his case and won. Then fifth, damage for loss or reputation. Damage for loss of reputation in case of breach of the contract are generally not recoverable. An exception to this rule exists in the case of the banker who wrongfully refused to honor a customer's check if the customer happens to be a tradesman. He can recover damages in respect of any loss to his trade reputation by the breach. And the rule of the law is the smaller the amount of the check dishonored, the large the amount of the damage awarded. Then six, damages for recurrences and discomfort. Damage can be recovered for physical inconvenience and discomfort. The general rule in this connection is that a measure of damage is not affected by the motive of the manner of the breach. Then finally, seventh, liquidate damage. What is a liquidate damage and how far it differ from penalty? Sometimes a parties to a contract stipulated at the time of its performance formation that a breach of the contract by either of them, a certain special sum will be payable as damage. Such a sum may amount to either liquidate damage or penalty. Liquidated damage represent a sum fixed or ascertained by the parties in the contract, which is a fair, good, genuine pre-estimated of the problem's loss that might ensure as a result of the breach. If it takes place, then and only then. Penalty is a sum named in the contract at the time of its formation, which is disproportion to the damage likely to occur as a result of the breach. Thus, penalty means an amount fixed in terronym without the regard to the problem loss. Quantum merit, the phase quantum merit literally means as much as earned. A right to sue on quantum merit arises where a contract party performed by one party has become discharged by the breach of the contract by other party. The right is founded not on the original contract, which is discharged or is void, but an implied promises by the other party to pay for what has been done. When an agreement is discovered to be void, when something is done without any intention to do so gratuitously. Second, when there is an express or implied contract to tender service, but there is no agreement as to remuneration. When third, when the completion of the contract has been prevented by the act of the other party to the contract. When the contract is divided, then when an individual contract is completely performed but badly, these are few things we have to take into consideration. Then now comes specific performance. In certain cases of breach of the contract, damages are not an adequate remedy. The court may in such cases direct the party in breach to carry out his promises according to the terms of the contract. This is a direction by the court for specific performance of the contract at the suit of the party, not in breach. Now comes injunctions. When a party is in breach of negative term of a contract, like where he is doing something which he promised not to do, the court may be issue of an order and retain to him from doing what he promised not to do. Such an order of the court is known as an injunction. So today we complete our lecture. How many questions comes from this lecture? So long question, short question. So first question can be, what is discharge of contract? Discuss in detail. Then it can be asked, what is discharge by performance? Describe in detail. What is discharge by agreement or contract consent? Describe in detail. What is discharge by operation of law? And what is discharge by breach of contract? And finally, remedies for breach of contract. Describe in detail. So these questions can be asked in the examination. With this note, we'll finish our this lecture. We'll continue this lecture in the next lecture. Till then, goodbye and take care. Thank you.
स्वाध्यायः परमं तप